From the Supreme Court to high courts across the country, this is LiveLaw Daily, your sharp, no-noise breakdown of the biggest legal developments shaping the country right now. I'm your host Tebujit Das, and here are today's top stories. The Supreme Court today delivered its verdict in the stray dog case that began after the Supreme Court on July 28th of last year had taken suo motu cognizance of a news item titled "City Hounded by Strays and Kids Pay Price." It was published in the Times of India, and the court made it clear that state governments and local authorities cannot keep treating the issue as an afterthought. A bench of Justices Vikramnath, Sandeep Mehta and N.V. Anjaria said there has been a discernible absence of sustained efforts by states and union territories to build the infrastructure required under the animal birth control framework. The court observed that if these measures had been implemented properly from the beginning, the situation would not have become this serious. The bench also linked the issue directly to Article 21. According to the court, the right to life includes the right of citizens to use public spaces without constantly fearing physical attacks. In one of the lines of the judgment, the court warned that allowing such conditions to continue would reduce public life to a Darwinian theory situation, survival of the fittest, which it said has no place in a constitutional democracy. The directions issued are extensive. Every district now must have at least one fully functional animal birth control center with trained staff and surgical facilities. Government hospitals have been directed to maintain stocks of anti-rabies vaccines and immunoglobulin. The court also allowed euthanasia of dogs that are incurably ill, rabid or dangerous, but strictly according to legal protocols. And this won't end with the judgment alone. High courts across the country have now been asked to register suo motu cases to keep track of whether these directions are actually being implemented on the ground. And for our second story here, we have Umar Khalid's bail matter. Umar Khalid will remain in jail after a Delhi court today rejected his plea for interim bail in the larger conspiracy case linked to the 2020 Northeast Delhi riots. Khalid has now spent over 6 years in custody under the UAPA. He had sought 15 days interim bail on two grounds: to attend the Chehlam ritual following the death of his uncle and to be present for his mother's surgery scheduled on June 2nd. But Additional Sessions Judge Sameer Bajpai of the Karkarduma court was not convinced on either count. On the religious ceremony, the court observed that if the relationship with the deceased was as close as it was claimed, Khalid would have sought bail immediately after the death and not at a later stage. On the second ground, the judge noted that Khalid's sisters and father were available to take care of his mother during the surgery and recovery period. The court also rejected the argument that interim bail should be granted because Khalid had complied with conditions during earlier periods of temporary release. The judge said past compliance does not automatically create a right to bail every time it is requested. The Delhi police had opposed the plea, arguing that Khalid's release could affect public order given the sensitivity of the case. And for our third story here, we'll take a look at the Delhi liquor policy and as it stands today, because two things happened simultaneously and they're connected. First, the main case. After Justice Swarnkant Sharma transferred CBI's plea challenging the discharge of the accused, the matter has now landed before Justice Manoj Jain. And since Kejriwal, Custodial and Durgesh Pathak were not appearing before Justice Sharma during the recusal controversy, Justice Jain has directed that fresh notices be issued to all the three. So effectively, the main case is restarting from the notice stage before a new judge. And now the second development, and this one runs parallel to the first one. The criminal contempt proceedings that Justice Sharma initiated against 6 AAP leaders, that is Arvind Kejriwal, Manish Sisodia, Sanjay Singh, Vinay Mishra, Durgesh Pathak and Saurabh Bharadwaj, over social media posts and allegedly defamatory content targeting her. Those contempt notices have now been formally issued. So you now have two separate proceedings running simultaneously in the Delhi High Court. One concerns the CBI's challenge to the discharge order in the excise policy case, and the other concerns contempt proceedings over the public attacks on a sitting judge during the recusal controversy. And our fourth story involves a partition suit, a paternity dispute, and a question courts are increasingly being asked. Can someone demand a DNA test to deny a woman her share in family property? The Andhra Pradesh High Court says no. The case involved a woman claiming rights in ancestral property through a partition suit. The opposing party argued she was not his biological daughter and sought a court-directed DNA test under the Civil Procedure Code. When she refused, he argued that the court should draw an adverse inference against her. Justice Tarlada Rajshekhar Rao rejected that argument. The court held that even if paternity is disputed, a DNA test cannot simply be insisted upon in partition proceedings. If a party wants to challenge paternity, the burden is to prove it through other legally admissible evidence, documents, witnesses, or other material. The court also relied on Supreme Court precedents warning against routine DNA or blood tests, especially because Indian law carries a strong presumption of legitimacy for children born during a valid marriage. And for a fifth story from Gujarat that enters completely new legal territory. A civil court in Gandhinagar has held that data stored in a deceased person's Apple iCloud account is a digital asset that forms part of their estate and can be inherited under Indian succession law. The case involved the family of a person who passed away without leaving a will. His wife and daughter wanted access to photographs, documents, voice notes, and other personal data stored on his iCloud account logged iPhone. Apple told the family that access could only be granted through a court-recognized legal representative. The court agreed that digital data qualifies as movable property and forms part of the estate of a deceased person. It appointed the deceased person's daughter as administrator of the estate and directed Apple to assist her in recovering the iCloud data, and where technically possible, data from the physical device as well. This appears to be among the first Indian court orders directly recognizing personal digital data as inheritable property. And for a next story here, the Supreme Court directly interacted with two accused persons in open court to check on their physical condition. The case concerns Aditya Anand, a software engineer and social worker, and Rupesh Roy, who is an auto driver, both arrested during the Noida workers' protest. According to the petition, they were participating in a peaceful protest demanding minimum wages and better working conditions. The Supreme Court had already made pointed observations during the previous hearing, with Justice B.V. Nagratna remarking that the accused were not terrorists and that subscribing to a leftist ideology does not make someone a criminal. Today, the bench of Justices B.V. Nagratna and Ujjal Bhuyan had the two accused physically produced before the court. Senior advocate Colin Gonsalves alleged custodial torture and sought a CBI investigation. One of the accused had told the court in Hindi, "Zabardasti mara pita gaya hai," alleging assault in custody. Justice Bhuyan then told the court, "Don't treat the workers like this." While the additional Solicitor General responded that they were not workers, he still agreed that every person must be treated with dignity. The court has continued their judicial custody for now, while allowing them liberty to pursue regular legal remedies. And for a seventh story here, we have the kite flying season in India that brings with it a recurring tragedy. Severe injuries and deaths caused by Chinese manja, the nylon thread coated with glass particles. And now the Uttar Pradesh government says it is drafting a dedicated law to deal with it. The state informed the Allahabad High Court that it is working on a proposed law called the UP Lethal Manja Prohibition Act. This legislation would regulate the manufacture, sale, and the use of dangerous manja and may also include compensation mechanisms for victims. The High Court noted that the issue has been pending since 2018 and pushed the state to speed up the process. The court also suggested identifying kite flying hotspots in cities so enforcement efforts can be focused in areas where illegal manja is most commonly sold. And for our final story here, the Supreme Court today heard a plea concerning the proposed naming of the Navi Mumbai International Airport after Loknete D.B. Patil. But the hearing quickly became a discussion on the limits of judicial intervention and the right to protest. When the petitioner sought a time-bound direction to the centre to take a decision on the naming issue, the Chief Justice of India asked whether deciding the name of an airport was even the court's function. The bench ultimately refused to pass such directions. The court was also informed that criminal cases were filed against young protesters. The court also informed that criminal cases were being filed against young protesters involved in demonstrations over the naming issue. The Chief Justice of India observed that everyone has the right to protest peacefully and lawfully, but not in a manner that causes disruption or law and order issues for others. With that, we wrap up LiveLaw Daily for today. Follow the podcast so you never miss an update that matters. We'll be back tomorrow with more from India's courts.